Welcome to Ivy and Ivy, Generations of Justice.
Hey everyone, welcome back to an all-new episode of Ivy and Ivy, Generations of Justice with attorneys Sam and Vic Ivy over at Ivy and Ivy Law. I am your host, Mike Leon. You know, they've got deep roots out in West Tennessee and decades of courtroom experience combined between the two of them. Sam and Vic have been representing individuals in serious personal injury cases, and they fight to secure full and fair compensation when someone else's negligence causes them harm. Today's episode, we're going to be breaking down how personal injury settlements are actually calculated in Tennessee. Sam and Vic are going to go over what goes into determining the case value, what factors matter the most, and why no two cases are ever the same. I'm sure you guys get that all the time. Clients are like, oh, I saw the billboard, right? My case has got to be worth this. So good to see you guys as always. Vic, let me ask you on that front. When someone does start asking you guys in that initial consultation, hey, how is my injury settlement calculated? How do you answer that? Where does the conversation begin?
Well, thanks for having us on, Mike, first of all. And let me just say, when we initially talk to a potential client, we always talk to them about three things. First of all, you have to have liability in a case, and that is that person has to be not at fault. Usually you have a driver who is a not at fault person who's been in a collision with another individual. So liability is the first thing. The second thing is damages. How bad is the person injured in this automobile accident? And surprisingly, some low impact collisions can create great damages or injuries to an individual. So we always look at damages. And then the third thing that we look at, is there a pocket to recover from? And usually it involves insurance. Insurance is usually available and the thing that protects individuals most. Of course, we can look at the at-fault party's assets and try to recover the assets of the at-fault party. However, that's more difficult to do, and a lot of times the at-fault party won't have any assets that you can recover from. Even sometimes we find that the at-fault party's in a rental car or a borrowed car or something like that. So hard to go after those assets in some of those cases. So the three things we look at, generally speaking, are liability, damages, the extent of the injuries, and also the insurance or assets of the at-fault party.
Sam, on the damages front, what are some of the other categories of damages in a Tennessee personal injury case? And is there a difference between economic and non-economic damages?
Yes, sir. So when we're looking at damages, as you said, Mike, the two main categories of those would be economic and non-economic damages. The economic damages are ones that we can easily put a dollar figure on. Those are going to be things such as the medical charges. We can show the complete amount of the medical charges to the jury and or adjuster or defense counsel in these Tennessee personal injury cases. Other elements of economic damages would include things such as lost wages, and then mileage to and from doctor's appointments and or any other expenses monetarily that are tied to the case, assisted devices such as crutches, TENS units and things of that nature. And then, Mike, as you look out into the future, you have other economic damages such as future lost wages, future loss of earning capacity, and future medical charges that may be applicable in serious injury cases. Non-economic damages, the other category you mentioned, are damages that are harder to put a dollar figure on, and ultimately that would be up to the jury to do that, Mike. That would include pain and suffering, loss of enjoyment of life, and permanency of injury. Those things are solely within the purview kind of the jury to put a dollar figure on, and that's where a lot of the negotiation comes in on these cases. If they're able to be settled short of trial, I mean, it's an interesting question as to what it would be worth for an injured person to, say, not be able to put shampoo on their head if they have a serious shoulder injury for many, many days after an accident. or any other activity of daily living that you could think of that might be affected by a wreck. So those are a few things that we look at with damages, just to briefly get into it in car wreck cases.
So, Vic, I want to touch on the medical part of this and medical expenses, future medical needs. How does that factor into settlement value, especially with, like Sam said, some of these cases are involving, long-term injuries?
Well, of course, with a long-term injury, what we're going to look at, we want the individual to reach their maximum medical improvement, get as well as they're going to, Mike. And once they do that, when we could start putting a value on the case. Obviously, if an individual, let's just say an orthopedic surgeon is in an automobile accident, injures his fingers, he's going to have a higher value than, say, an individual used mostly just a back, like a roofer. But if a roofer, an individual had a chosen occupation as a roofer, injured his back, he would have a higher value claim. So it just depends upon obviously the occupation of an individual, how severely that they are injured or damaged. Now, that medical information that you just asked me about, that proof would come in at trial, and we would introduce that proof through the depositions of treating physicians, and it would come in, and that is exactly how we establish the value in the case at trial, is we use that medical proof and the amounts that those doctors used to treat the individual. So it'll be the extent of the injury and more or less the occupation of the individual, even though it shouldn't come into it. The age of the individual comes in, their hobbies, those sorts of things, what their usual life, treatment, life value is. We calculate all those things, and that all comes in at trial.
Sam, Vic gave an example there, like let's say a surgeon losing some ability in his hand, right? Like that's going to affect his job. So lost wages seems straightforward to me, but how do you kind of calculate lost earning capacity if someone, like that example that your dad gave, like they can't return to that same job or career?
Yeah. So, Mike, in Tennessee, you have wide latitude as to how to prove those economic damages. And of course, the interesting thing is it's really up to the jury to set that award. So you never know what 12 people are really going to do until they render a verdict, or 8 in federal court. But what we'll do in those cases, Mike, if it's a significant lost wages or loss of earning capacity claim, many times we rely on expert opinions to be introduced at trial that help bolster that particular category of damages. Economists help us a lot with permanent injury cases on putting together a value of how much in lost wages this person or lost earning capacity this person is going to accrue over their lifetime using life expectancy tables. And then also life care planners help us a whole lot in discounting for present value what that particular economist may have put down as like damages that the person would be out in lost wages because of this permanent injury. So it gets kind of technical and detailed with those claims, and you have to rely on experts many times to maximize the value of those claims in front of the jury.
Vic, in a previous episode, we were talking about insurance coverage with underinsured and uninsured. What role does insurance coverage kind of play in shaping a settlement, even if the damages, let's say, are clearly significant?
It's going to make a huge difference, Mike, because if a person has severe injuries and they may have hundreds of thousands of dollars in medical bills, then if there's not adequate insurance to cover, or liability or uninsured motorist coverage to cover those medical bills, then a lot of times the insurance companies will go ahead and pay out their maximum amount that they have in those cases. In those, we have to look at the assets of the at-fault party in those automobile accidents to see if there are additional assets that we can recover. So you could get, even though you hate to say a quick settlement on some of these cases, they are quicker than maybe where there is an exorbitant amount of insurance. The person may have, fairly insignificant injuries and a lot of insurance, and it may take longer to recover on that case because you're waiting to you actually have to kind of talk it out with the insurance company. A lot of times we wind up filing suit on those cases and have to fight that out in court, which is, as I alluded to earlier, an adversarial proceeding all the way around.
Sam, we haven't really touched on comparative fault in the state of Tennessee. I would love for you to kind of explain that, but also how does comparative fault affect the final settlement amount if both drivers do share some responsibility in the accident?
Sure. So in Tennessee, we have a modified comparative fault system on personal injury cases. And a lot of times that comes up, for example, in automobile accident cases that are a large portion of our cases. And what that law is in Tennessee is a plaintiff has to be less than 50% at fault for a wreck to recover from their injuries. So if we were to, for example, go to trial in a case and the jury found, for example, that our client was 35% at fault for the accident, the other driver was the lion's share at fault for the accident, then whatever amount in damages that the jury awarded for our client, it would get reduced by that portion of fault that the jury found our client to be responsible for. So that's the gamble all the way around too, Mike, is the comparative fault issue if it's not a clear liability case. And that's something to be considered in case valuation too, as you go through these things, is what is the portion of liability each party shares in this accident, and take a real look at those. And we always are honest with our clients in assessing cases. And so if you've been in one of these, you have questions about it, give us a call and we'll be glad to walk through the scenarios with you for free and see if you're a good fit to take on as a client in an automobile accident case.
Yeah, that's great advice for folks out there. Vic, we talked about you guys always, prepare for trial, right? So can you kind of walk us through how trial readiness influences settlement negotiations before the case actually even reaches the courtroom?
Well, it does, and the insurance companies and insurance lawyers know that we prepare for trial at Ivy constantly. Each and every case that we take, we prepare for trial on that. So generally speaking, what will happen is the individual will be treating at some medical facility. We get that medical proof, and we're always trying to wait until the individual's finished treating with that doctor so that we know the amount of medical proof and the amount of injuries, whether you have permanent injuries, whether or not the huge difference between if you have like a back strain case or a whiplash case versus permanent type injuries, broken bones, nerve injuries, that sort of thing. So we wait and look for the maximum medical improvement of the individual. Once we have that, we start preparing by using experts that on the medical side of it that we're going to use at trial. Now, prior to that, we may have had to use experts to determine liability in the case. So as we're looking at trial, Mike, we're always looking at those three things that we talked about earlier, and that being the liability. So first we have to establish that, and we do that at trial even. We have to establish liability. Then we're always looking at the amount of damages or the extent of damages, whether a person has a permanent injury or a temporary type injury. And then we look at the pocket that we're trying to recover from. So, which a lot of times is the insurance rather than the assets of the individual, although it can be the assets of an individual. So we're constantly preparing for trial. And even though we're preparing for trial, even when we get into trial, we are very, very careful about the words that we use, because we may need to use those words, the record, on appeal if we get an unfavorable decision. So we're constantly preparing for trial. Folks that, hire lawyers just for a quick and easy settlement are making a mistake. They should hire experienced lawyers that are ready for trial. The big difference when you get in trial and something goes wrong, you can tell the inexperience on a lawyer. They look like a deer in the headlights, and they, don't know what question to ask next or how to recover from that. So you need an experienced attorney. We've got that at Ivy and Ivy.
Well, I love that you said one phrase there that I'm going to ask as the follow up here as we put a bow on the episode, which is about the quick settlement type of offers. So, Sam, what would you guys want someone that's listening to this to kind of, and maybe they have a serious injury, right? What would you want them to understand about the difference between jumping on that quick offer versus a properly evaluated settlement?
So to get a fair amount of compensation out of a case, if you're seriously injured, it's a tough row to hoe, Mike, because it takes time to build the case and get there. Whether it be working it up and you're able to eventually settle the case, or as Dad said, going to trial. It takes many, many months and sometimes years to get there to get proper compensation for some of these cases. And so what I would say to anyone out there going through that, or someone has been offered a quick settlement by an insurance company, give us a call for a free consultation. It's no cost to you to walk through the scenarios with us and let us see if this is something that we can help you with, build your case. You know, we've seen many cases where it appears that the injury is quite insignificant at the outset, and it turns out to be a serious injury that they need months and months of treatment for. And those cases take time, but we're right there with our clients every step of the way, and we try our best to guide them through the road to recovery as we work to obtain them a recovery in their personal injury case. So give us a call. We'll be glad to help you.
Yep. That consultation is free, as everyone knows, right, guys? Gents, thanks as always for the time, the insights, explaining this to the audience. I appreciate it, guys.
Thank you, Mark.
And thank you to everyone out there for listening to this installment of Ivy and Ivy, Generations of Justice. If you've been injured in a serious accident and you've still got questions about what your case may involve, Sam and Vic are here to help you understand your options, protect your future. Do me a favor right now, visit ivyandivy.com to schedule that free consultation like Sam mentioned. And one more favor, as always, hit like, hit subscribe, leave a review, comment, share the episode with someone who needs to hear it. I'm Mike Leon. We will see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.